Well, friends, Donald Trump is once again gagged in his case in Washington, D.C., and this time, Judge Tanya Chutkan helpfully spoon-fed Donald some examples of the things he can say and the things he can't say. Let's talk about that, because justice matters. Hey all, Glenn Kirshner here. So friends, after a brief pause, Judge Tanya Chutkan reimposed her gag order on Donald Trump, prohibiting Trump from talking about, intimidating, harassing, threatening witnesses, court staff, or the prosecutors. Let's start with a new reporting. This from Politico. Headline, Judge reinstates gag order against Trump. And that article begins, a federal judge has reinstated a gag order against Donald Trump, lifting a temporary hold she placed on it earlier this month and rejecting his claim that it unconstitutionally limits his free speech. U.S. District Court Judge Tanya Chutkan paused the gag order on October 20th amid Trump's complaints that it was confusingly worded and requests that she keep it on hold while he asked a federal appeals court to throw it out altogether. But in a 9-page Sunday evening opinion, Judge Chutkan reinstated her order, rejecting Trump's claims that the order was unclear or that it unconstitutionally restricted his free speech rights. In addition, Chutkan noted that one of Trump's recent statements, an attack on his former chief of staff, Mark Meadows, would almost certainly violate the order had it been in effect. Now, friends, I want to take a few minutes going through Judge Chutkan's 9-page written ruling reimposing the gag order on Donald Trump. And if I could respectfully urge you all to consider reading it. It's an easy read. It's an important read. I'll put a link to the judge's order in the description of this video. And Judge Chutkan's order will be published in the law books, but it will also be important reading in America's history books. So let's turn to Judge Chutkan's order. So there is Judge Chutkan's opinion and order, and it starts out with a discussion basically of the factors to be applied, the test, when somebody is trying to stay or stop or pause an order from going into effect, which is what Donald Trump was trying to do, try to pause or stop the gag order from being imposed while he appealed it. And she set out the different elements of the test, saying there are 4 factors that guide the decision whether to stay or pause an order pending appeal. Number 1, whether the stay applicant, that is Trump, has made a strong showing that he is likely to succeed on the merits. And friends, when we flip over to page 2, Judge Chutkan pretty promptly answers that question, quote, defendant Trump has not made a strong showing that he is likely to succeed on the merits. And here's what she says. As the court has explained, the First Amendment rights of participants in criminal proceedings must yield, when necessary, to the orderly administration of justice, a principle reflected in Supreme Court precedent, the federal rules of criminal procedure, and the local criminal rules. And contrary to defendant Trump's argument, the right to a fair trial is not his alone, but belongs also to the government and to the public. What does that mean? It belongs to us. It belongs to we the people. We have a right to a fair trial as well. Judge Chutkan then really quickly dispatches several of the legal arguments Trump's lawyers make. Defendants' other claims disregard the record. In other words, Trump and his lawyers simply ignore the facts of record that don't seem to support what they're asking the judge to do. She then takes up the defendant's claim that the court gave no meaningful consideration to alternative, less restrictive measures, including a narrower gag order, and the judge says, again, the record flatly contradicts Trump's claim. She then goes on to say the defendant's final claim is that the order is unconstitutionally vague for various reasons, none of which withstand scrutiny. First, the defendant quotes Merriam-Webster Online's definition of the word interested, but interested party is a well-established legal term of art, and a cardinal rule of interpretation of words is that context matters. A word is known by the company it keeps. And friends, I've skipped over a bunch of her analysis because basically what she does is expose that the defense team, Donald Trump's lawyers, just sort of selectively ignore anything in the record that doesn't support their claim. So I read you her conclusions, but I now want to turn to what I think is the most interesting and possibly the most important part of her ruling, of her opinion. She turns to two of Trump's recent posts and she spoon feeds Donald Trump the do's and the don'ts of her gag order. And this is going to take a few minutes to get through, so I hope you'll bear with me, friends. She says, two of defendant's social media posts since the order's entry illustrate the comprehensible difference between the statements the gag order permits and those it proscribes or prohibits. First, on October 22nd, 2023, the defendant stated, "Does anyone notice that the election-rigging Biden administration never goes after the riggers, but only after those that want to catch and expose the rigging dogs? Massive information and 100% evidence will be made available during the corrupt trials started by our political opponent. We will never let 2020 happen again. Look at the result. Our country is being destroyed. MAGA." This statement asserts that defendant is innocent, that his prosecution is politically motivated, and that the Biden administration is corrupt. It does not violate the order's prohibition of targeting certain individuals. In fact, the order expressly permits such assertions. Judge Chutkan then turns to another of Donald Trump's posts. By contrast, on October 24th, 2023, after the gag order was administratively stayed, in other words, when she temporarily lifted it, when she paused it, here is what Trump posted. "I don't think Mark Meadows would lie about the rigged and stolen," misspelled, 2020 presidential election, merely for getting immunity against persecution by deranged prosecutor Jack Smith. But when you really think about it, after being hounded like a dog for 3 years, told you'll be going to jail for the rest of your life, your money and your family will be forever gone, and we're not at all interested in exposing those that did the rigging. If you say bad things about that terrible monster Donald Trump, we won't put you in prison. You can keep your family and your wealth, and perhaps if you can make up some really horrible stuff, out him," so you know Donald Trump wrote this, "we may very well erect a statue of you in the middle of our decaying and now very violent capital, Washington, D.C. Some people would make that deal, but they are weaklings and cowards and so bad for the future, our failing nation." That's 3 for those of you scoring at home. "I don't think that Mark Meadows is one of them, but who really knows? Make America great again." And friends, here's what Judge Chutkan said about that statement, that post that Donald Trump made during that very brief period of time when she paused or stayed the gag order. This statement would almost certainly violate the order under any reasonable definition of targeting. Indeed, defendant Trump and his lawyers appears to concede as much, saying if the gag order had been in effect, President Trump would have been unable to make that statement, and for good reason. The statement singles out a foreseeable witness, that is Mark Meadows, for purposes of characterizing his potentially unfavorable testimony as a lie made up to secure immunity, and it attacks him as a weakling and coward if he provides that unfavorable testimony, an attack that could readily be interpreted as an attempt to influence or prevent the witness's participation in the case. The plain distinctions between this statement and the prior one, apparent to the court and both parties, demonstrate that far from being arbitrary or standardless, the order's prohibition on targeting statements can be straightforwardly understood and applied. So friends, the only question now is when, not if, but when will Donald Trump violate the reimposed gag order? And when he does, what will Judge Chutkan do? We've already seen Donald Trump repeatedly violate the gag order imposed up in his New York fraud case imposed by Judge Engoron. He's violated it multiple times. He's received some money sanctions that mean nothing to him because all he does is grift off his base some more to satisfy those fines, those money sanctions. So let's hope Judge Chutkan enforces the gag order once violated by Donald Trump by doing what the law allows. Indeed, by doing what the law demands. Revoking Donald Trump's pretrial release and detaining him pending trial. Sitting him in a jail cell pending trial. Because that will protect the witnesses. That will protect the court staff. That will protect the prosecutors. And that may be the only way we, the people, have any hope of receiving the fair trial the Constitution says we are entitled to. Because justice matters. Friends, as always, please stay safe, please stay tuned, and I look forward to talking with you all again tomorrow.